So much, ma'am. It's indeed an honor to be here today. And this is not the usual audience that we speak to. We generally speak to lawyers, law students, because that's where we talk about dispute resolution. So this is a new audience for me. So I had to do a lot of homework in terms of construction sector before I came here and spoke to any of you. So I can assure you that as far as possible, I have read into construction contracts and all the trends in construction contracts recently. So I just wanted to briefly give you an overview and outline as to what we will be looking at today, because at the very outset, I realized that for some of you all, it must have been quite a question as to why are we talking about dispute resolution as engineers, and what exactly can a lawyer tell us in this regard. So just to give you a brief outline as to the agenda. Sorry, I'm trying to go to the next slide. Thank you. All right. So first, we will try to understand the nature of a dispute, because although we talk about disputes all the time, sometimes we forget to really talk about what a dispute actually is. So we will briefly look at that, and then let's try to understand basic differences and characteristics of different types of dispute resolution methods. Now, I know that in construction contracts, you're mostly aware of adjudication, arbitration, because those are the two main methods that you use when it comes to construction contracts. However, during today's session, I also want to emphasize how negotiation, mediation, conciliation come into this picture, and what are the ways in which we can bring those methods in our contracts. Next, let's look at the legal framework when it comes to construction dispute resolution. So let's look at the CEDA Act and also the standard bidding documents that are there under CEDA. And I also want to take a look at FIDIC 2017 contracts, the forms that we have, the books that you look at. And then I also thought to have a brief look at JCT and also NECs, because I realized I had some interactions with quantity surveyors and contractors recently, because there are a lot of discussions going on the revival of construction industry. So these are some of the contracts that they spoke about and said these are the contracts that we can look at and learn from. So I tried to go through those contracts as well in terms of dispute resolution and how best we can incorporate those novel trends into our system when it comes to dispute resolution. In discussing all of this, we will also look at the role of an engineer in the dispute resolution process, because different people have different roles when it comes to dispute resolution. A lawyer's role in this process is quite different from what a quantity surveyor would do, and that is different from what an engineer would do. So from the research that I did and from the people that I spoke to with regard to the role of an engineer, what I understood, please correct me if I'm wrong, is that you are this vital third pillar when it comes to a construction contract. You have your employer, you have the contractor, and you are that pillar that cannot go missing, who would at one time act as the agent of the employer, but at the same time who would have to act as that neutral third party who makes fair and unbiased decisions to make the contract going. So you have a lot on your shoulders other than the mathematical duties that you do, that somebody who's looking at an engineer from an outside would think an engineer is a person who deals with numbers all the time. But from what I understood, you do a lot more than that. Dispute resolution is one of them, one of those most difficult tasks that you deal with in a construction. So if I have got all of that right, I hope I'll be able to share with you some important insights as to all these key areas that I am hoping to cover with all of you today. But there will be a bit of a difference. I am not very much in favor of one-way lecturing. So you will have to work with me And I'm going to learn from you because you are the subject expert in the area. So what I can tell you is I can throw some ideas at you. You can tell me whether you are in confirmation of those or whether you disagree, and then we can build a discussion on that. So to start with, I have a question for all of you. What is a dispute? Now, from what I understand, you deal with disputes from the start of a contract till the end, and even after you build a building for many years, after many years, a dispute can come with regard to whatever that you have built and you have supervised, right? So I think we have given you a small booklet with a file. So in that, it's a notebook. If you can take a piece of paper from that book or on the book itself, I want you to draw something that comes to your mind when you think of a dispute. I do this exercise with a lot of people, including law students, lawyers of different seniority. So I have seen how people look at disputes. So let's see how engineers look at disputes. So I just want you to draw something that comes to your mind that would explain what a dispute is like. I'm sure most of you would be able to draw very nicely, though I am not a really good artist. But don't worry about the quality of the art. Just putting your thought would be sufficient. It's best if you don't write any words. I generally tell lawyers not to do that because lawyers are very, pros in writing like pages and pages and pages. So that's why I said to draw something, just a small thing. Okay, if you're done, I have to again now trouble you to explain what you have drawn. So I will just do a random picking, okay? And I want you to help us understand how that picture explains a dispute. I'll try to explain it to those who are joining virtually. Yeah. Can I trouble you, ma'am? If have you drawn? Yes? No? Okay. Can I trouble you, sir? Yes. Okay.
Yes, thank you. There's a letter from construction party. He is telling that is the termination, but other side of the employer, he is telling that is not the termination.
Can I get that paper, please, so that our virtual participants can also see the picture? So this is what the picture is. It's one party is, yes, the contractor is giving a paper termination of contract, and the employer is saying that it is not termination. All right, thank you very much. So I think this is a depiction of the experiences that you have in terms of construction industry as to start of a dispute. If we break it down further, this is where one party feels that there is a termination, whereas the other party feels that there is not. So if you take it in simple terms, this is a disagreement on opinions or perspectives. When I look at the existing circumstances, one party feels that this contract cannot be continued, therefore you have to terminate it. Other party thinks no, it should not be, or rather other party would take up a very legal technical argument saying your document does not amount to a termination per se. Right? Okay, thank you very much. I will trouble one more or two more people. Maybe I apologize for just pointing out from what you're wearing only because I don't know your names. Can I trouble you, miss? No? Maybe you can pass the picture and I'll try to understand what it is. Maybe you can tell me whether I have done it wrong. You didn't draw? Okay, okay. Ma'am, can I trouble you, please? Yeah, you can even come here.
Well, this is
Yeah, can we show it today? Yeah, maybe explain.
no what this dispute is. According to the contract documents, there are limitations. What are the borrowing depth? We have to go inside the prop, right? But people try to interpret it in such a way that they will go for from the cutoff point. They have to go another depth, but now I am not much. I can't remember exactly the figures, but there is a dispute in that decision. So this is what I want.
All right, thank you very much, ma'am. So that once again is, I think, a point on interpretation. People have their own interpretations, and according to each person's interpretation, you have disputes arising. Do we have any volunteers so that I don't have to point out, but somebody who wants to? Yes, please. Yes. Yeah. Okay. Can you explain, please?
Yeah. The mainly dispute, there are three parties in a project. That is the engineer, the employer is the required person, and the engineer is the person who design it, and the contractor. The dispute between these three parties because of one is the money or the cost, another one is the time, another one is the standard and regulations and every specs and everything. So I try to summarize it like this. So thank you.
Okay, thank you very much. So that's where when all parties are in dispute, what is at stake? Your time is at stake, your wealth is at stake, and you are constantly troubled to follow rules and regulations. So all these things are at stake when you're at a dispute. So what I wanted to actually get from this exercise is to understand how you perceive disputes. Now, if I am to tell you now, I told you that I do this exercise very often. So I'm sure you're now wondering, okay, what are the things that lawyers do, right? So I share this particular thing that a group of young lawyers, we train junior lawyers. So a group of young lawyers did, when I did this training once, they said, disputes are like a tuba ice cream. Have you had tuba ice cream? No? It generally comes, the tuba ice cream that I have had, the most famous and the first one that came was Faluda. Faluda tuba. It has two flavors. But if you just look at it without its cover, it's pink and it looks like it's either strawberry or Faluda. But you have to eat it to see. When you take a bite, you can feel that in the middle, there is a vanilla layer. So they thought that disputes are like a tuba ice cream. What do you think? Do you think that's right? Yes or no? Yes. Why do you think so? Yes, two different opinions. So that's one way of looking at it. What else? So instead of chocolate cake today, if I asked engineer Himal, Mr. Himal, to bring tuba ice creams for all of you today, but we give it to you without the cover, right? If we gave you a pink color ice cream without telling you what it is, then how many of you all will take it and eat it? A simple question, because some people don't like Faluda or strawberry, right? But some love vanilla. But when you look at the ice cream, you wouldn't know that there is vanilla, right? So you might sometimes take it and eat. If you are a hater of vanilla ice cream, The moment you realize there's vanilla in it, you will be like, oh, I don't want to eat this. Right? So why did that group of young lawyers say that disputes are like a tuba ice cream is because sometimes when you look at a dispute, what you can see from the outside is not what is there inside, right? Disputes come out or are expressed in different forms, like just like this letter of termination. It will come out as a termination letter, which will, if you try to deal with that letter, it's simply a letter of termination saying, okay, we can't work. We have to terminate it under what hardship or force majeure or whatever clause they will say we have to terminate. You have not made payments for this long. Hey, therefore, you have violated substantial amount of your obligations. Fundamental breach of contract, we are terminating. Those are the legal terms that will come with that. But sometimes when you look at the dispute, when you go into the dispute, you will realize that, well, it's not really that, but sometimes it might be the ego of the contractor. Very high ego, doesn't want to listen to the engineer at all. Always fights with the engineer, doesn't take engineer's word, at all, always doubts the engineer's impartiality and wants to get into trouble. So now instead of resolving that, he is now coming and giving a letter of termination to the employer and saying, look, I can't continue this. But if you look at it, what has happened is over a period of time, he has been, having trouble with the engineer or something. Just an example. But I'm sure you must have experienced that kind of situations. Because particularly I have heard of things like when you have very big contractors, sometimes it's very difficult to convince them on your advice or instructions that come from the engineer, right? So it can be situations like that. So internationally, people who talk about dispute resolution say that disputes are like an iceberg. Okay. Why is that? Once again, in an iceberg, there is a part that you can see and a part that you can't see, right? What happens when you don't see that bottom part? What happens is, what happened to what? Now, there was a disaster that was caused because somebody didn't see the bottom part. Yes, Titanic, right? What happened was they thought the top part was, they calculated the distance towards the iceberg by looking at the top part of the iceberg. They completely disregarded the fact that there can be a bottom layer that you can't see, which might be closer to the ship, right? So the bottom part can be either very big or completely different from size, nature, everything to the top part. So similarly, in disputes, there can be a part that you can't see, not can be, there is often a part that you can't see, neglection of which can lead to disastrous consequences. If you just look at the top part and try to address the top part, you might be left with a disaster in the end, just like what happened to Titanic, right? So that's why it's important for us to first know, as people who are engaged in dispute resolution, that not every dispute comes to you as it is with all its characteristics. Nobody brings to you a dispute and says all about it. Because all what you will see is what? A disagreement, notice of disagreement, dissatisfaction, NOD, right? You just see that. It might come with a lot of technical terms, but you might not know anything more than that. This is very much, this example relates a lot to lawyers, because when clients come to lawyers, they come and sit and they start talking. Now, none of this happens to you, I think. But in your case, mostly it's a technical matter that will come, right? But let's say your clients or the contractor comes to you and brings a extension of time claim, and then tells you, තේරෙනවනේ සර් මේක කරන්න බෑනේ දැන් මෙච්චර ප්‍රශ්න තියෙනවා මේ කාලේ බඩු ගේන්නත් බෑ and all of that, and might give you a justification, but he might not tell you all the things, right? He's always going to give you the picture that he wants you to see, right? Not the picture that should be shown to you. So if you are not aware of this fact very well, sometimes it can lead to disastrous consequences. Sometimes you might just decide, okay, I'm going to approve it. Or sometimes you might decide, okay, I am not. It's whether it's this way or the other, if we are not aware of the side that we can't see, it can be disastrous. So first thing in dispute resolution is dispute diagnosis. That is where we understand the part that we can't see. This part can have so many things. Personalities, historical developments, like I said, for a long time you might have had problems, and now at a point where, like for a very silly matter, suddenly there's a big problem. Nobody can understand as to why this man is taking such a harsh stance for this small thing, right? But it's not very small when you really look at the historical development of the events. It can be simply egos. It can be simple fear. Because of fears, people take extreme measures. Now, I think even like recently we see that some internet just immediately they were thinking of stopping these things in end of year, and now they're suddenly stopping in end of February we are stopping, right? That's all what they say, and everyone is in trouble, right? So there can be so many reasons behind these decisions that we really don't see. Okay, so it's very important for us to first understand this part that we cannot see. Now, my question to you is, how do you do that? Oh, it's not as hard as the maths that you deal with. Okay. It's actually a process of questioning, but not questions that we as lawyers ask in the courthouse in cross-examination, not that type of questions. Generally, you can get to the bottom of a problem. See, that's in colloquial language, we say, no, I'll get to the bottom of that. It's the bottom of this that we talk about all the time. You know, without knowing it, we say that, no, I'll get to the bottom of that problem. So you just have to keep asking open-ended questions, right? Why do you really think that this contract cannot be taken forward? In your opinion, what is stopping this? Right? So let people talk about it a lot more, because papers will not carry everything. Papers oftentimes carries half. The full part you have to extract. And that doesn't come out even in general adjudication or arbitration. It doesn't come out because you always work on this top part, positions. But if you really want to get to the bottom of it, you have to ask these open-ended questions and then identify the part that you can't see. That is where we talk about dispute diagnosis. Only when you know what this dispute is really about, you can decide the type of method that you want to use to resolve this dispute. Okay. Now, if I want to stop here, I know now in your minds, so many questions are piling up. One, how can we do that? I mean, in the contract already the dispute resolution clause is there. Now, what is she talking about? How can we decide after diagnosis? Okay, I know all of it is there. Let me slowly come to that. But I'm just giving you the ideal situation. Whatever it is, you have to first do the dispute diagnosis. Okay, identify whether it's a dispute that is arising out of data. Now, see, these are causes to a conflict. There can be so many types of reasons for a conflict. Most of the times in construction disputes or anything that involves mathematics or data, it would come as a data conflict. It can either be lack of information. There might be things that you know Employer knows, contractor doesn't. Contractor knows, subcontractor doesn't know. Right? So information has not passed, especially when it comes to variation. Right? Sometimes the variation request has gone and the contractor has done some variations and informed the engineer. Engineer's approval has not gone. Now the payment is delayed. Things in between, communication, numbers, information. So there can be so many different types of reasons. But if you do the diagnosis properly, you can identify it. Now imagine if there is there can be conflicts where it at the very outset looks like a number matter, mathematical issue, but when you really look at it, it might be a simple miscommunication. But if you try to handle the numbers at the very outset, leaving out miscommunication, you're just leaving space for the next problem, and the next problem, because you have not addressed the bottom of the problem. Okay, so it's very important to do the dispute analysis, identify the causes for the conflict that you're dealing with. Okay, now once again, we come to the point, how do we do that as engineers? Because this is not where your process starts, right? Your process starts at a different place. Okay, so we will go through these few things quickly because we are going to get to the most important parts thereafter. Now, this Thomas Kilmann model is a model that was introduced by Thomas and Kilmann, who did some research on disputes as to how, as humans, we deal with disputes. It will help you to also understand some of the new additions to dispute resolution mechanisms in the construction industry. All right. So this is how generally people handle disputes. Now we know of the normal scenario from even when we went to schools. Our parents used to normally tell us, right? To avoid not to get into disputes. When you can sense a dispute, just leave it. Right? Now I want you to keep this part in mind because we are going to talk about the dispute avoidance boards, the concept that they have now introduced into construction disputes, especially. That's a new concept. So to avoid disputes altogether, not to let disputes happen. When you sense it, you do something and you not let the dispute take place. To mature as a dispute. Then there is also a situation where we are very accommodating. I'm okay. Mostly in relationship disputes, we see one party is very accommodating until some time till that party kind of gives up completely, right? So you can either be very accommodating in a dispute. You also have the other extreme where you compete. That is what happens in arbitration and litigation. You compete on your stances. You would say, no, I cannot give you an extension of time. You have to pay costs for the delay. There is no extension. It was not approved. Your situation cannot be justified. You have to pay the charges that we are imposing on you for the delay. Right? And the other party will say, no, we are entitled to this extension of time because of these reasons. In that other project, that engineer approved that under the same circumstances. Why can't you do it? Right? So you have two different positions. People are competing on their own justifications. Mostly happens in adjudication, arbitration, litigation. This is what happens. You try to prove your position. Then you have a place of compromising. Now I want you to tell me what is better, compromising or collaborating? Compromising is better. Any other opinions? Anybody who thinks that collaboration is better than compromise? What is collaboration? What is compromise? What's the difference? Yes, give and take is compromise. In a way, yes. So I will take that in a way part, because in compromise, both parties give up on something to have something, right? I will give this to have this, you give that to have that, right? So both parties have a sense of loss. They both feel that we gave up on something, but we had to do it to safeguard this. Collaboration is different. Collaboration is where you don't really focus on the loss. You focus on the gain and you try to come up with a solution that will be much more when you compare your loss against your gain. So a collaborative effort, you would not feel like you have lost. Now I'll take a very simple example. This is a question to you once again. Now let's assume, I assume that most of the people who are here would have kids at home, at least most, right? Even if you're thinking of having kids, just take this example and think of a future answer. Let's say, has any of you all heard the orange example earlier? Anybody? Yeah, I know one person. Okay, maybe you have to now keep your mouth shut without saying anything. Others, you don't know, right? Okay. So let's assume there's an orange on this table and all your kids are here. Now I take one parent up and let's assume you have two kids, a daughter and a son. Now both of them are saying they want the orange. Daughter is saying, I went with you to the shop and I showed you this orange and then you brought it. I carried the bag and brought this home. This is my orange. Son is saying, it just true she brought the bag in the car, but I got out of the vehicle carrying that bag. I am the one who put it in the fridge. If I didn't put it in the fridge, it would have rotten. Nobody would have been able to eat it. So I saved the orange. I preserved it. Therefore, it's mine. Now I want you to tell me, how will you resolve this dispute? Now this is far easier than your construction disputes. Okay, you will cut the orange into two and give. Will they be happy? Why? They have half now. Why would they be not happy? They wanted the whole orange and now they are concentrating on the loss, right? What do they know? I only got a half. She also got a half. She doesn't deserve that half. And the sister would think the same thing, right? Why did you give him a half? He doesn't deserve that half. That's my half, right? Now everybody sees a half. But this is exactly what we do in the formal justice system. That is called distributive justice. You make sure everyone has something. Or you go with the standard principles of justice. You divide it in half. That's a very standard idea, right? When two people are fighting for something, we think dividing it in half is the best way, right? Even if you go to a courthouse or arbitration, most of the times they would go on this objective criteria to make a decision on that. Two people fighting for it. What is the most recognized way of doing this? They would go on that. That's what we also did with the orange now for that. Any other answers? Keeping in mind what we did at the very beginning of this session. Now, is there a dispute between the two? Yes. Now, can you see the whole dispute? Yes. Now, this is a test to see how well you understood the first part of the session. There can be other oranges. Okay, in this hypothetical scenario, no other oranges. You can't afford two oranges these days. Just one. Tell them to negotiate. Not capable of doing that. Exactly. Now remember, we knew that in a dispute, you don't see the entire dispute, but you only see half of it. So you need to first do the dispute diagnosis. You have to get to the bottom of it, right? But we made a prejudgment. We thought it's just a dispute. What more can be there, right? We always do that. We make a prejudgment that there's nothing other than this. But technically, what you should, like he very well said, is to understand why do they want this orange in the first place. Right? If you want to give a good answer, good solution to them. Okay, now there are two types of answers to this question. When the parent asks the daughter and son, why do they want? First scenario, this is the scenario that is taught in Harvard program of negotiation. The daughter would say, I want to make a pudding. The son would say, I am thirsty, I want to have an orange juice. Now, how will you divide the orange? Exactly. Now, for that, you need to first know how to make a pudding with orange. How do you make pudding with orange? You need the zest. You just need the peel for that. You don't need the pulp. For the juice, you need the pulp. So you get the entirety of the peel to the daughter. Go and make the pudding, use as much as zest you want. Entire peel. For the son who wants the juice, take the entirety of the pulp. Have they lost anything? No. Is there a sense of loss at all? No, they got what they want. But had we gone on to give a decision without knowing why they want it, what have we caused? Wastage of resources. Person who wants the drink would use that half the pulp and make a drink and throw away that other peel, which the daughter could have used. Son could have very well used the other pulp that the daughter is going to just throw away, because now they're angry at each other. They are never going to give that other half, even if they get to know that the other person will benefit from it. That's the nature of humans. Once you lose once, you're never going to give up, right? So that is why it's important to do the dispute diagnosis well before, so that you can come up with the best form of decision that will give both parties a winning solution without a compromise. Now that's an easy scenario. When this scenario was given, I was thinking to myself, oh, that's easy. They wanted two different things now. Now, what if they both want juice? Now, how will you resolve the dispute? Now, trust me again, this is the easiest kind of dispute you can ever get. Now, they both want juice, you have one orange. We can even give the opportunity to virtual participants. If you all have answers, please do type it in. I will share it. You can type it on the chat if you have answers. Don't know what to do? There's an answer. Okay. Sorry, what's the question? Yeah, so so now both kids, if you heard the previous part, now both kids want orange. There's one orange. Both kids want the orange and both are saying they want juice. How will you resolve this problem? Dilute the juice. Okay, wait. Okay, what do you mean by dilute?
How many
Just two kids. 2 cups.
Sure.
can we reduce that?
Exactly. So, Mr. Hamas, right? Yeah. So he gave the answer. In fact, I wouldn't say dilute, but if you just take it like so you said, without dividing the orange itself, you value add to the orange. If the mother takes the orange, make a juice out of it, what do? You squeeze the orange, You can add some water, like he says, dilute, okay? You can add some water. Maybe mothers put some, lime into it, a little bit of salt. If you want a little bit of sugar, and make a nice juice out of it, then you have enough to give them both. They are both getting the same juice. Is there a wastage? No wastage. But if you divide it in half and give both of them to make their own juice, will they be happy? They won't be. Now remember, oranges, no matter how hard you try to cut it in half, in one part, the peel might be thicker than the other part. Okay? You never know. You might try to do justice, but justice might not be there. Right? But if you value add it and then divide, that will give you a better outcome where nobody will feel as if they lost something. That is collaboration. You address their needs in a creative manner. You have to do a little bit of thinking to come up with that solution. Now, why did I do this part for all of you? Is because as engineers, you are the masterminds of that contract, right? That's why you are one of the 3 pillars holding the construction project. Without you, it can't go forward, right? Regardless of who else is there. So it's your brain that will know best ways of resolving certain disputes, some creative solutions. You will be able to think of things that others will never be able to think of, right? But your brain can do that only if you give your brain that opportunity. Because we are often closed, we are blind to it. Even this orange example, not that we never knew that you can make orange out of juice out of an orange, no. But to think that it will be a solution, it takes a little bit of opening up. We have to first be open to our own creativity. We have to first know that we are people who are capable of finding solutions. The moment we restrict ourselves, we rely on a third party to give us answers. Now, our culture, particularly the Asian culture, is as such, we have been trained to rely on a third party. Podikale, when 2 kids fight in the class, what do our parents tell us to do? Or what do you say of kids? They either avoid or, no, let's say somebody hits your son or daughter. Okay, really? Wow, that's amazing if you say that, but do we say that? Tell the teacher. That's what we say, right? We always want people or even ourselves to rely on somebody to give us a solution. Now, if you look at adjudication, is that what we do? Arbitration, is that what we do? Litigation, is that what we do? Yes. Sometimes we go to arbitrators who have never even set a foot to a construction site, and we ask them to resolve a construction dispute. Right? And sometimes they don't understand what a SBD is. Sometimes they might not understand the very basic mathematics that you do. When you just take a glance at it, you know what it is, right? They might not understand. So you might have to call for expert witnesses who go explaining everything that you're taught in the first year of engineering faculty, right? Applies to me as well. I'm a lawyer. I wouldn't know anything about your mathematics, right? Some concepts. Now, I'm not saying that judges or who don't have this experience can't hear these cases. I'm not saying that. What I'm saying is we are very comfortable relying on other people to give us solutions, right? Even if you go on Facebook, everyone comes and put all their problems there and ask, please, somebody help me. Asking help is not bad. Please don't misinterpret. But what I am saying is we have not been trained to think of solutions. Have our parents ever asked us when we are in a dispute or a problem, okay, what do you think is the solution? Have they ever asked us? Or do you even ask your kids? Do you ask them, do you know the solution? What do you think can be the solution? Oh, we don't, because we think they are incapable. And we think we are incapable of finding solutions. So this part is only to tell you that we all have that capability. And you being the masterminds of contracts, construction particularly, you have that ability. When I do this training for commercial entities, we tell them they are the business people, right? They are business minds. They are the best people to find best solutions for their businesses because it's your thing. You know how to get out of it, right? So first, once you do the dispute diagnosis, parallel to that, tell yourself that I know how to find solutions. At least I can try. Failing, go to an expert. It's okay. I'm not saying don't do that ever. But starting point, try to do that. Okay. Right. Okay, so then we come to the technical part. Now we know, do the dispute diagnosis, be ready to collaborate, not always compromise. Don't think about resolving. Settlement means compromise. That's a myth. Settlement doesn't always mean compromise. It can be collaboration. Hold hands together, walk towards a solution that gives you a lot more than give and take. It can be a completely new solution like making juice, the mother making the juice. Okay. Now we come to different methods that are available for you to resolve your disputes. First one, as you all know, it's negotiation. Negotiations can happen in two ways, formal and informal. Informal one will not involve lawyers most of the times. It might not sometimes even involve yourself as engineers. It might simply go between the employer and the contractor in certain instances, when it's heavily on business concepts or something like that. It might also involve you. That can still be a negotiation, right? However, the most important thing in negotiation is you are the decision maker. You decide whether you want to settle or not. It's your game. You decide the terms. Yeah. You decide whether you are going to settle. If so, on what terms are you going to settle? Now, in a negotiation, most important thing is that you prepare a negotiation strategy. Now, one thing to know is we do go for negotiations. You have all been part of so many settlements in your career. But how often have you prepared for a negotiation properly? Have you ever discussed a negotiation strategy? Now, this might not apply to your role as, let's say, a project engineer, because sometimes you might not take a side, right? But if you are advising a particular contractor on something in a consultancy capacity from that contractor's side, or if you're advising an employer, not as the project engineer, but in any other capacity, you might have to become a part of negotiations and take a side, not be a neutral. Okay, now let's make that clear. Not as the project engineer who has to be neutral, but as an engineer who advises to either of the two parties, in employer or the contractor. Then you have to have a negotiation strategy. Now, how do you come up with a negotiation strategy? We generally do a SWOT analysis. A SWOT analysis, all of you must be knowing, it's a strengths, weaknesses, opportunities, threats analysis in that particular dispute. Parallel to a dispute diagnosis, you do a SWOT analysis, then you identify your BATNAs and VATNAs. What is a BATNA? BATNA is a best alternative to your negotiated settlement. Before you go to the negotiation, you need to know what would be my best alternative. If you don't have a best alternative, you are weak in your negotiation because you can't walk out of it. You're scared. If this fails, you don't know what else to do. So to face a negotiation with a strong footing, you need to first identify what your BATNA is. You go to the negotiation thinking, okay, I need to get an outcome that is better than my BATNA. If not, I am not settling. That's your top point. If the settlement is worse than your BATNA, you have to walk out. You can't sign that agreement because you have a better alternative. Okay, so that's why for a negotiation, BATNA is important. Then you need to know what your BATNA is. That's your worst alternative. Obviously, your settlement has to be a lot better than your BATNA. Okay. Next thing, we also learn a concept. I haven't put all of those here, but I will just give you the overview so that you know what to go and maybe do some further reading on. There's something called Malatna, MLATNA. Malatna is the it's where most likely agreement to a negotiated settlement. That's very similar to the concept of ZOPA. That's zone of possible agreement. When you draft your strategy, you can circle a particular area and say, like we do in Venn diagrams, or Venn circles, and the area settlement. You have to come up with a possible zone. Then you will know how to generate options. මේ area එකේ තමයි මේ settlement එකේ ඉන්නේ. මොකද අර පැත්ත කීයටවත් මේ කැලලා අයින් කරන්නේ. දැන් හිම you can come up with a measurement, no? These people are never going to give up on this aspect. This is a vital interest for them. So you have to first identify your interests, their interests. My positions, their positions. My weakness, their weakness. My strength, their strength. My opportunity, their opportunity. So a SWOT is not only for you. You have to do a SWOT for them. Then set each party's interest and then see what's the ZOPA is. Then where can you place your creative options? If your creative options fall within that ZOPA, then you have won more than half the game. Because when you go to the negotiation table and drop these offers that are actually in the ZOPA, other party can't reject. Because your option really addresses their interest. That's why it falls within the ZOPA. Z, zone of possible agreement. Okay, so these are the things that we have to strategize on. I apologize, I can't take more time on this, but I have just thrown in all the concepts that are relevant in the area, so you can do further readings on that. Next thing is mediation. Now this is, we think we are very familiar about it because of the Sammata Mandali. I promise that I will clarify this. Now, first clarification that I want to make is mediation is not Sammata Mandali. Sammata Mandali is only a place where they are supposed to use mediation. Internationally, there are community mediation practices. Community mediation is Sammata Mandali, where you get a free mediation service. Now, first disclaimer is in Sri Lanka, you don't see a proper mediation practice in Sammata Mandali. This is accepted across from, I know of Supreme Court justices who agree with this stance. Because in Sri Lanka, what we see is a mixed method, a hybrid method of mediation and conciliation when it comes to Sammata Mandali. So what happens in mediation? It's a facilitated negotiation. It's actually a negotiation. Decision-making power is with the parties. Parties have control over everything. But there is a neutral third party who helps you negotiate. Third-party mediator cannot make decisions in a mediation. Mediator can't tell the parties, you do this. He can't give his own ideas. Okay, there is a very thin line, actually it's not thin, between that and conciliation. So mediation is a facilitated negotiation where the mediator only facilitates the process. Now you might think, what is that? Is there anything to do? Of course there is. Negotiations oftentimes fail when there is no neutral third party, because negotiations can come into an impasse because of egos, communication gaps, and inability to focus. Because when we start a negotiation, two parties, you can talk about everything irrelevant, but what is relevant. And you can't ask the other party, we have to focus, because then they get mad and their egos get hurt and, you know. So there are a lot of politics in a negotiation like that. You need a third party to tell you, okay, calm down. We need to now focus. This is where we are. Let's take it like this. Let's be respectful and ask questions to help you focus and go through a process till the end. That is what a mediator does, not tell you what to do and what not to do as to the resolution. Okay. So there's high party autonomy, settlement agreement. Now, we often hear that are mediations binding? Are mediation settlements binding? No. What are the cases? Yeah, that also doesn't say that. Anybody who would say yes? No, actually, that's not what that act also says. But the answer is there in this slide. What happens in a mediated settlement agreement? At the end of a mediation, what do you do? So if you agree on some settlement terms, you sign an agreement. Is it binding or not? Is it binding? Okay. So how is it binding? It's an agreement. Now, I don't say anything why you did. I mean, yes, you said no, because that is what we have been taught. At the very outset, in any of the dispute resolution, not trainings actually, even at law faculty, the first time when I learned the module, what was taught was mediation is not binding. But that's wrong. Mediated settlement agreements are binding as much as a contract, because it's an agreement between two parties. So long as, yes. No, that's a contract actually. It is as good as your construction contract. It has the same value of that contract. So long as it is not vitiated by factors such as misrepresentation, fraud, duress. Then ඒවා තියෙනවා නම් construction contract එකත් valid නෑනේ. Construction contract එක contractual validity එකට relevant වෙන all 6 principles තියෙන capacity, legality, offer, acceptance, consideration. ඒ ටික තියෙනවා නම් mediated settlement agreement is a contract. But this was a myth that has been there for quite a long time in Sri Lanka. So I even published a paper on that as to how it becomes a contract. And the academia agreed on that, not only because the academia agreed, even the Court of Appeal justices have given judgments on that, saying under the Civil Procedure Code, there is a provision which says you can settle. So when settling also, what happens is you come into a settlement agreement. So the justices say when you have settled, it has the same value of a binding contract. Once you agree to settle, you can't go back and say, it was just a settlement, I didn't know. You can't say all of that. If you agree to settle on certain things, you have agreed. You are bound by it. Difference is whether these agreements are directly enforceable or not. Now, these agreements are binding as a contract, enforceable as a contract. So, the settlement agreement is not directly enforceable in Sri Lanka till now. But the Mediation Act is being drafted right now. So, we hope that it will also come in. If you take the Singapore Mediation Act says once you settle, you have to simply take the settlement agreement, give it to court and say, I want you to enforce these clauses. Court will issue a decree on that. There is a law for that. So, and there is now UN convention on mediation, which enforces the internationally mediated contracts, just like the New York Convention for Arbitration. So mediation has gained that popularity, and those agreements are and can be enforceable. They are binding. So do not get scared to go for mediation. People get scared thinking they are not binding. So what's the use of it? Right? That's wrong. If you are to be careful in signing your contract, when it comes to a construction, fearing that I will be legally bound, you have to have the same fear when you sign a settlement agreement. That's why mediation is important. That's why you have to go prepared for that negotiation. Okay. Now, how it happens in general is parties are represented with lawyers in mediations. Now, in Samatha Mandalaya, oka wenne. Samatha Mandalaya Act itself leave the lawyers out. But international level and professional mediation level, you go with your lawyer. If you want, if your engineer, whoever your technical expert, because at the negotiation table, you have to decide on your interests, your liabilities, your capacity, everything. Right? So it's a big process. It's not a subtle process. That's what I wanted to emphasize. It is a process that carries legal validity. Then these acts, Mediation Boards Act, Mediation Special Categories Act, those two apply to Samatha Mandalaya, community mediation. Construction Industry Development Act, CEDA, the act that you know, Section 50 says parties may, if they can't settle it on their own, refer to mediation or conciliation by the authority. So the authority has the power to provide mediation, conciliation services. So if you want to, you can go and get those services from the authority. I think Himal and them are looking at giving those services from the authority. But one thing that I want to clarify is that act is very clear on may. It's an option for you. It's not compulsory. So if somebody thinks if we are to mediate, we have to go through the CEDA, that's not correct. It's an option. If you take a closer look at CEDA Act, every other section, professional person shall register. It's all those things are shall. Those are compulsory requirements that it sets out. But this, they specifically use the word may. If the parties so wish, I think that's the reading. So it clearly gives the parties the autonomy, because mediation is technically a voluntary process. You can decide who your mediator should be, where do you want to do your mediation, all of that. So it's party autonomy. Okay. Then even if you take SBDs, I will go to that later, we'll finish this first. Then you have Commercial Mediation Act. This act, though it came in 2000, Sri Lanka is very famous for this. This center was never set up. There were so many attempts by leading professionals like Ms. Dara Vijay Tilaka and all of them, and Chamber of Commerce, to set up this center, but they couldn't do it because of several inefficiencies in the act itself. So the act is there, no center. Companies Act also recognize Part 20, specifically companies disputes to be resolved through mediation. So I just wanted to tell you how important and what type of importance Sri Lankan law has given to mediation. Because we sometimes look down on it. We think it's not a proper process. It's not binding. That's not true. Then in mediation, there are also concepts like judicial mediation, where the judge mediates. We also have this concept in Sri Lanka, Sri Lankan Court of Appeal, Supreme Court mediation rule. There is a Supreme Court rule which says Court of Appeal can mediate appeal matters. Judges to sit as mediators. Court of Appeal judges can sit as mediators, and in Court of Appeal they can mediate. Rule came in 1990, once again still not happening, but the rule is there, and actually now the judges are looking into this. Because all around the world, Canada, high level of success in appeal mediation by judges. So that is happening in the world. Singapore, specially judges are trained in this subject. Court annexed mediation is another concept where the courts themselves refer matters for mediation. I don't want to emphasize on all of this because that's more or very much relevant to lawyers. But just to know that mediation is important. Okay, then we come to conciliation. Most important thing is to understand the difference between mediation and conciliation. Like I said, the line between mediation and conciliation is conciliator has a power of decision making. Mediator does not have a power of decision making. So that's why even in CEDA, you have the two terms, mediation or conciliation. So you have to make the decision very carefully. Do I want a third party who can make decisions, or do I want myself to make decisions? Do I only want a facilitator? Based on that only you decide what your method is. Okay, so that's the difference. Conciliator, but can be a little bit more facilitative as well, as opposed to an arbitrator or an adjudicator. Now, the adjudicator will never ask you what your solution is, no? But a conciliator will. Conciliator will ask you, do you have an option? Do you think this is better? He will put some suggestions and see. But if you can't agree on any of those things, he will finally give a decision and he will try to make you agree to that. Mediator can't do those things. But I also want to stress upon the fact that in mediation also there are different types of mediation. Evaluative mediation comes very, very close to conciliation. But there is where you have a very thin line. Now, if you go to Singapore construction mediators come very close to evaluative mediation. That's very close to conciliation. But they still don't impose the solution on you, but they bring you closer to that, very close to that. Because sometimes construction disputes can be highly technical. No? So if the mediator is only facilitating, sometimes it can be disappointing to the parties if the mediator can't show some guidance. So if the parties require the mediator to show some guidance, such mediators will come close to an evaluative mediation mode. But you still can't cross to conciliation where you impose on the parties. Okay, got the differences? Is that clear? Okay, thank you. Yeah. Generally, that's how your contract defines it. Like now, let's say Debt Conciliation Act, I have set out it here. The Act says conciliated decision is binding according to the Act. So it depends on under which law you're going for conciliation. If your contract says it's up to the parties or that you can challenge it, then it's not necessarily binding or final rather. But actually that is how you term it in your dispute resolution clause. Now as project engineers, you might or might not have a control over that. Sometimes if you have to go with a standard clause or if you come into the contract after the contract has been drafted and agreed upon. But if you're an advisor to an employer who's trying to come up with a contract, then you can essentially play an advisory role and say, look, this is how you have to draft this clause. Don't set to one thing. What I always encourage is to go for a mixed method. Keep it open to go for an amicable settlement at any point of time. I will show you how.
Saying that you can't modify the orders in the speedy other than the volume do filling the blank side. Other than that, you can't changes.
Correct. So what I'm saying is not to make changes to that, but I will show you how the SBD clauses actually leave you space to get into this. So, all right. So in conciliation, I wouldn't go to any more complexities because the most important part was explained. Then we come to adjudication. In the construction industry, you're very much familiar with this. Dispute adjudication boards, expert determinations, neutral evaluation. Whatever the name you call it, ultimately what happens is there is a third party expert to whom you make submissions, then that expert gives you a decision. Again, based on the law under which you are going for this, it can be final, it can be not final. Right? There are certain laws, I mean, even the CEDA, even SBDs, what tells you is within 28 days, if you don't challenge it through arbitration, that becomes a final and binding decision. Correct? So that's again how the term has been, how that dispute resolution clause is worded and where this is placed. Okay. Since you are very much aware about this, I'm not going to explain it any further. Arbitration. So that's like the last resort in construction industry, right? You don't want to go to litigation, but you try to go for arbitration, because arbitration and litigation is either or. You can't have both, but you finally get pushed on to litigation, because if you want to get it enforced, you have to go to court either way. Now what has happened is you spend years in arbitration, then you spend some more years in litigation. So the whole point of arbitration is lost, right? So that's why once again, we encourage you to think of amicable settlement even when you go for these processes. How? I will start with the Arbitration Act. Now this applies to SBDs as well. All the SBDs say if you are challenging adjudication decision, you have to go for arbitration. And the SBD also says arbitration, the law governing arbitration, Lex Arbitri would be what? Arbitration Act of Sri Lanka, 11 of 1996. Section 14 of 11 of this Act says, from the moment you initiate an arbitration, and at any point of time, you can settle the matter through mediation, conciliation, or any other method. So just because you have an arbitration clause in your agreement, it doesn't mean that you can't mediate. It doesn't mean you can't negotiate. It doesn't mean you can't conciliate. So if you know this section, it's simply a matter of asking the tribunal, saying the tribunal, we want to settle this, suspend the proceedings until we come up with a solution. Now you don't have to do with this to all the issues. Now in an arbitration, you raise several issues, issue 1, 2, 3, 4, 5. You can decide, okay, why don't we negotiate issue 1 and 3? That we can negotiate. Let's arbitrate 3 and 4. So you continue arbitration on 3 and 4. Parallelly, you go with mediating 1 and 3. You're saving a lot of time. You don't have to lead evidence, make submissions on 1 and 3. But once you arrive at the settlement, Act says you can submit the terms of settlement to the tribunal, and tribunal has to convert it into an award. So it's as good as an arbitral award. But you get it through mediation or negotiation or conciliation or whatever the method you want.
So, the adjudication, when the decision was came, they can go to the court and make it final. The final system was there.
Yeah.
Why Sri Lanka, it is not.
So actually that is because party autonomy is vested with the parties. Now let's say it's a very adjudication, it's a process where you select a particular person and you entrust that person with making a decision for you, right? But if you are aggrieved with that, this system, you have no other person to go and complain to. That's your final place, right? Whether you agree or not. Here the system has given you more space, if you're not agreeing, to go for a more rigid process where it's a fully fledged hearing. In adjudication, you don't get a full hearing like you do in arbitration or in litigation. It's mostly submissions. But once again, what I'm saying is it's actually up to you. If you are happy with it. Now the UK system, if parties think that no, adjudication is sufficient, we just want to get some decision, that's fine. Right? But the law, in Sri Lankan law has not codified it in such a way that you make it final. But if CEDA thinks that it can be made final, and if parties are happy with that, that's a different thing. But it has to come into your agreement. Because ultimately, contracts are, what's the ultimate document? It's your contract. Right? It's up to parties autonomy. So if you decide that this is the best way, adjudication shall be final between the parties? It's actually up to parties, right? The whole reason why you go to arbitration is, I think, in personal views, because you get a fully fledged hearing thereafter, and it's governed by law in a very rigid process, right? You have a law governing your arbitration, there are rules, then you have a process of enforcement. But now, like Mr. Imar said, if there is a direct process of enforcement, actually some people prefer that, because then you can't challenge it. But drafters has not thought that way. But if as industry you think adjudicators award is as good as, I mean, it's good enough to be a final decision, actually I think that's something maybe as an industry you should discuss on. It's up to the parties actually. This question was in fact also asked from one of the Supreme Court justices with whom we did a webinar also. This question was put to him. So this is what he also said.
Actually, it's like orange. They are not satisfied. Then go to the litigation. Every time
Exactly. So that's because one person's view is not accepted, no? Because expert opinions can also vary. And it's only one person in adjudication. Whereas in arbitration, you have 3 people and you go with the majority. So there are so many reasons as to why it's not just adjudication that's binding, but you go for an arbitration process.
But there are, it's more than 5 and there are 3 parties there. Chairman
And for adjudication.
Yeah.
Okay, yeah. So then of course, I mean, once again, up to the parties. That's what I think.
Standard adjudication, not practicing. It was said when you are signed the agreement, so in some particular days, they have to go for the standard education. But what was happening in advocacy? So that's why it's like this conciliation.
I think that's where the sir said. I mean, in CEDA, the rules are the process of adjudication is not set out. Therefore, people go for ad hoc.
Not set up. Anyhow, in SBD2, it's the procedure rule was there, but in practice, it was not happened because they has to pay for the educator at the beginning of the project. That's a huge cost. Then at that time, the contractor and the employer not willing to go for the educator.
Yeah, because you don't foresee a dispute. Yeah, I think this is the same concept that would come with dispute adjudication and avoidance boards, where you have a disputes board who would come and constantly visit the site and see whether there's a dispute that's going to come up and then take preventive action. But for big projects, I think that's a very smart idea to do, because you don't know when a dispute would come, but you obviously know there will be disputes. Yes, so in arbitration, what I wanted to emphasize was, don't restrict yourself to one. Find the law which says that you can go, and try to find the most effective way of resolving the dispute, not to restrict yourself to this one method if there is scope to go further. Litigation, judicial adjudication, of course, you know how it happens in courts. You have no control. Whatever the lawyer tells the judge listens to it and then gives you a decision. So your role there is limited to the highest level. All what you can do is get on the witness box, answer the questions that are put to you, right? So you can't do anything beyond that. So the importance of all these methods is that you understand the method that can give you the most amount of space to use your expert knowledge, and you find that method for your advantage. Now, I just went through some of these contracts, so you might have to tell me whether you agree or disagree. Because I don't know, I really didn't find an article which put all of these things together. So SBDs 1, 2, 3, and 4, there's no direct reference to mediation, negotiation, or conciliation. Am I right? Correct. It starts with adjudication, right? If there is a dispute arising, you go for adjudication. But party autonomy in any contract is key when it comes to a dispute. So I believe you have the right to go for a supplementary agreement if you really want to mediate before you go for adjudication. Because SBD doesn't give you a time bar. Unlike some other contract forms, where there might be a time bar saying if you have a dispute within 10 days, issue notice of adjudication. Okay, go for an adjudication. Issue that you have, tell the other party that you have a dispute. There is no time bar. It doesn't tell you when to go for an adjudication. I am just showing you ways. Okay. So, it doesn't stop you from negotiating when you know there is a dispute. You can always start with a negotiation. You can try mediation. If you want to preserve a good relationship, imagine it's a massive construction project. In between, you have a dispute. Now, if you are to take this dispute to adjudication and then to arbitration, you are hampering your relationship with your contractor. And it's going to be a nightmare to have that construction project continue till the end once you have a bad relationship, right? So it's always good to attempt negotiation. But from what I have been told, I am told that this is the practice, though it's not on paper, that you always try to do it on an unofficial basis. You try to negotiate, right? Mediation to a certain informal extent, but not in the proper process. So I think it's always wise for us to explore this possibility because that opportunity is there. You're not time barred. If you are time barred, then you're at a problem. Because whatever that you do, you have to do within that time and then go for adjudication. But here it doesn't time bar you. So you can try all of these things. Failing, you can go for adjudication as the proper dispute resolution method. But if you settle beforehand, who's stopping you? Nobody will even know that you had a dispute, which is a good thing. Right? It's good for you, your contractor, it's good for your employer. Your employer will love you for being that engineer who could save him from adjudication and huge costs of arbitration. Right?
If one person before go for an application, they shall practice this mediation or conciliation. But thing is that the Act was came 2014, this document was developed in 2007 or something. Because of that, it was not harmonized with the Act.
Exactly. They are not harmonized.
That's right. We wish to
Do that. Okay, yes. So what I want to tell you is space is there. So it's in your hands. You can do that. But always good to go for a supplement agreement, like a agreement to mediate, agreement to negotiate, so that at a later stage, nobody can come back and say, we never agreed to do that. We don't know who you sat with. He didn't have the authority. You don't want those problems. So you will put it down. These are the people who will represent the employer. These are the people who will represent the contractor. This is the person who will be the mediator, and then you do the mediation accordingly. You can always go for a mediation center. There are mediation centers who have mediation rules. Even if your arbitration clause is ICC, International Chamber of Commerce, you still have possibility to mediate. So this is what I want to tell you. Don't worry about the words that are in your contract only. There are ways in which you can mediate, you can amicably settle. Amicable settlement is not something illegal to do. It's just that you have to find the legal way of doing it. Proper way of doing it. Selection of Arbitration Act, I already talked about section 14. So even if there is arbitration, now SBD, so you start with negotiation, mediation, you go for adjudication. If you are not happy, you challenge and go for arbitration. Even when arbitration is ongoing, if you think still there is some possibility, because now everybody has spent so much money, all are frustrated with a lot of time spent, now they might want to settle. You know, you never know. Because I know of a case where after 20 years of an IP battle, in the Supreme Court level, they settled. Two big companies. Right? After fighting for 20 years, they settled. So if they can settle after 20 years, definitely whatever the stage, because you might think, by the time it comes to arbitration, they don't want to settle. No, don't prejudge. You never know. So always put it to the parties and ask the parties if you have that ability. Once again, not as the project engineer, but maybe if you do it both parties, that will be fair, but don't just push one party. Yeah, so then CEDA Act, I told you mediation or conciliation, but though it says by the authority, it doesn't stop you from going for your own private mediations and conciliation. Okay, it's an option for you because sometimes parties wouldn't know where to get it. Yes, then go to CEDA to get it. FIDIC, all of you are very much familiar with it than myself, but I just went through the yellow book and the red book has similar provisions. I was told that mostly used is the red book. Am I right? I was told. So what it says essentially is it gives engineer a special role. I found this very, very interesting. Because there it says clause 21, engineer is to consult with the parties to encourage them to reach an agreement. So that's exactly what a mediator does. This is essentially telling you that the engineer can act as the mediator. Because if the engineer is to act impartially, if the engineer is a neutral, if the engineer is to be fair for both parties, engineer has all the qualities to become a mediator. But I always say that it's best you get trained as a mediator, accredited as a mediator, because the mediation process, you have to learn the skills of a mediator and all of those things. But your position is very much valuable for you to act as a mediator in this process, because both parties have faith in you. That's why you're given that position, right? If the two parties don't trust you, you can't be the engineer of that project anymore, right? So FIDIC 2017, this clause essentially places you in a position of a mediator. And that's the starting point. And it gives you 42 days to explore this. If in 42 days you can't get them to agree amicably, then only you go to your determination as the engineer. Right? So this I thought is a very good point for us to know. As engineers, you can play a role of a mediator in the dispute resolution process. Then you have the DAABs, that's the newest concept, which is Dispute Avoidance and Adjudication Board. It has two roles. One is a preventive role, second one is the adjudication role, the usual dispute adjudication. Now the avoidance part is where again the disputes avoidance board has to act as a mediator. They can sense a dispute coming, they will bring the two parties and get them to now agree on a way to avoid this dispute. Parties themselves come to the decision. But it's the same board that will then have to adjudicate it if this is not avoided and resolved. Now, UK, there are case law to say that this dual role is contradictory. I will tell you why. Actually, the judges have also said why, so not just me saying. It's because in mediation, there is a rule that is called without prejudice and it's confidential. Okay? Even arbitration is confidential. So mediation, confidential, and there is a double confidentiality when it comes to a private session with a mediator. Whatever one party tells me, I can't tell the other party if this party doesn't want me to tell that to the other party. So it's a double confidentiality also. Now, what happens when I mediate with them and then I also adjudicate with them? All the confidential information that you shared with me, I know all of them. They're all in my brain when I go to adjudicate. Right? So the without prejudice part, where you say without prejudice means without prejudice to your legal rights and interests. Right? So whatever you shared with me thinking that I will not use them against you, now if I am the adjudicate, I will have to use them. Because now I know, technically I can't. But obvious biases are there, right? I have heard all the confidential things. I might use it. So the courts in the UK have already held that this is a conflicting situation. You can't have both, same body doing both. This is exactly why I noted SBD 4 says adjudicator to mediate. It can't happen because when the adjudicator mediates, adjudicator becomes aware of all the confidential things and then he adjudicates. So that goes against the basic principles of mediation. So that's one concern. Then there is another amicable settlement option. Now see how the process comes. They have given you first time to again settle, then another avoidance period is there. Again, you have amicable settlement option within 28 days before challenging the adjudication decision. Just like here, even under SBD, you have 28 within 28 days challenge. But did we ever think that within those 28 days we can negotiate? No, what we do is, we draft papers and we plan for arbitration, right? But see, here they have clearly identified that 28 days is also for you to reconsider settlement, because now you're going to end up in a big battle, right? But like I said, even in that big battle, if you want, you can settle, particularly under the Sri Lankan Act. You can start the battle and then also settle. There's enough an opportunity for you to come in and creatively settle. Right? Only problem is we are most of the times blind to it. We do not know. We think it's all in the hands of our lawyers and the arbitrators, and then we come back. Thank you. So we go to their chambers, file එක දීලා එයාගොල්ලන් consultation එන්න කිව්වම මේ දවස්වල ගිහලා consultation එකේ ඉඳගෙන ඉඳලා අහන ප්‍රශ්න ටිකට උත්තර දීලා we come back thinking now they have to resolve this. No, don't do that. Engage in the process from the start to the end at every possible time, because you feel the pulse of the project, right? You know whether there's a possibility. ඊළඟට තියෙන මේ කාලේ මෙතනදී පොඩ්ඩක් settle කරගන්න පුළුවන්. Now the tension is down. Both parties are frustrated. Let me try to see if we can settle. Because finishing it early is good for you all, right? Remember, it's not the same for lawyers. Finishing it early is not their interest, right? So you have to be aware of what your interest is. Now, don't think I'm a lawyer and talking against lawyers. No, for lawyers, what we say is, faster we can resolve disputes, more the matters that come to us, right? More the trust we earn. So it's a two-way process. Not bad for either party, good for both parties. Yeah, so that's for arbitration. Then JCT and NECs, even in the joint contracts tribunal, those contracts, standard bidding contracts, 2016 version, I think that is the latest version. Am I right? This is what I was able to find. Yeah, this is what I found, the latest. So clause 9(1) says, it starts with mediation. How it starts is, if the parties fail to amicably settle, then you go for mediation. So starts with mediation after a failed negotiation. So if the parties can't settle, then you start with a mediation. Then NEC contracts, actually, they don't refer to mediation or conciliation. If you look at NECs, you will see that they have options W1, W2, W3. This is what I saw. I'm very new to this, but this is the research that I have got. So what they say is, these options have a very interesting part called senior representative. I haven't gone much into see who a senior representative can be, but I kind of guessed that it can be a role like an engineer who is impartial, neutral, and is able to be fair in the process. So, yes. So, senior representative option is essentially a place where you can use mediation and negotiation, because it gives the opportunity for the senior representative to see whether it can be settled. In that process, what the senior representative can use are these methods. So these contracts might not sometimes directly tell you that whether it's mediation, negotiation, or conciliation. But it might leave you space. If it says parties to decide, parties to settle, remember that's an indication of party autonomy. They are giving you the decision-making power. In the dispute resolution methods we now discussed, mediation, negotiation are the top two methods which gives you fullest party autonomy. So you look at the wording, you see whether there's party autonomy, then you look at the dispute resolution methods and pick the methods which gives you that highest party autonomy. Then you see whether you can find a way in the contract to facilitate using this method. That way, you can find the most appropriate method to resolve your disputes with less cost, less time, and safeguarding the interests of your employer as well as your contractor, working collaboratively. So my final point is mediation or negotiation does not have to end up in a compromise. They can end up in a collaboration so long as you put on your creative hats and use your expertise to come up with a collaborative solution that addresses the interests of all parties. Thank you very much. Yes. As per FIDIC 2017, engineer no need to act impartial. Are you referring to the agent concept, is it? Sajal. Sorry? Hi, Sajal. Yes. So yes, I understand that. That's why I said, I think the contract started where they said engineer to be an entirely impartial person. But it seems that the concept has changed over time. And now this law of agency and identifying the engineer as an agent of the employer has now surfaced. So it's there. That's why if the engineer is to act as a mediator, what you need is parties' consent. If the parties are willing to accept you as a neutral third party, if the parties can place confidence in you to act neutral, then you can mediate. That's why I said, if whenever you are going for such an agreement, get it in writing. Before every mediation, we sign something called an agreement to mediate. In that agreement, we say both parties agree to appoint this person as the mediator. So if you agree to appoint that, then no problem. But I agree on this point. Without doing that, if you just automatically assume, anybody can later raise this point and say, mediator was not really impartial because he was also acting as the agent of the employer at some point, because that's true. No? You act as the agent of the employer at some point when you give instructions, right? So, yes, correct. Does that answer your question, Sajal? Yes, we can also. Okay. Can a mediator propose suitable options? Yes. So that's why I said you have a very thin line there. If the parties request you to act in an evaluative manner, you can, but we generally do those in private sessions. Now, I was not able to tell you what the mediation process is because the time is limited. In a mediation process, you have joint sessions and private sessions. Private sessions, mediator meets with each party separately. And then you then you can just put it on the table to a party to consider. But that also, if the parties are comfortable of you doing that, so to facilitate this process, before a mediation, we conduct something called a pre-mediation conference. Before the mediation, we meet with the parties separately. Generally, now it happens on a Teams call or something. Then we ask them what their special needs are. So if the parties tell us, look, we prefer if you can take a more evaluative and helpful approach in this process, then the mediator can take an evaluative process. But the key line is you can't impose on them. You can't tell them, this is very easy matter, nothing to consider. You pay him this much, you do this. You can't do that. It's up to the parties. In a private session, surfacing solutions if the parties are struggling with finding a way to get out, then yes. I hope that's no, you don't sign an agreement with the mediator, but before the mediation, mediator will ask you to, the two parties to sign an agreement to mediate. Because see, mediator doesn't get himself involved in the decision process, decision-making process at all. But now different countries' mediation laws require different things. Now in Singapore, if you want to enforce one, it says either you have to be a certified mediator, you know, to place your signature as to the fact that you conducted that mediation, or your mediation has to be conducted in a center that is recognized under the law. But now in Sri Lanka, we still don't have that. So either way, if you have a valid agreement, that's why I said when you go for a mediation or a negotiation, it's always advisable to take your lawyer with you. Because at the end of the settlement, you have to get your lawyer to draft your settlement terms. Lawyer will only know how to best draft those settlements. See, that's where we come together. You can do the thinking, you can negotiate, you can bring in the new solution, but we as lawyers help you put it into legal terms and make sure that there is no lacuna in terms of the law or legal validity of this binding contract. You know, I have witnessed this mediation in Singapore. Started at 9, we finished by 5. The two parties came with their senior lawyer, junior lawyer, and an intern, two huge firms in Singapore. So after the settlement terms were agreed on, it was the job of the lawyers. They drafted then and there. From this end to that agreement was emailed to that room. Then they both agreed on terms. We all got together to one room, main room. There's a huge screen. On the screen, the entire agreement goes from one to start to end. Matter closed. One day. It's possible to do that. It's just that you have to follow that process. Oh. All right. Okay. Please explain a bit about ancestral model law. That will take a bit of time, but yeah, maybe on another day, if there's time, I will explain on ancestral model law because it's a lot. I don't think I can just rush through it. Because there are two, of course, you have to talk about arbitration and then or talk about mediation, so it's a lot. Talking about agreements, can we sign agreements with comments even though contractors, clients are upset on it? Being an engineer, we can't accept something wrong knowing it's wrong. Is there any other way to face this kind of situation? No, you don't have to agree on anything if your client and contractors are upset. That's why you need to have, now see, even this process is a negotiation. That's what we don't realize. Before you sign a contract, every communication back and forth is a negotiation. So get prepared very well for those negotiations. Don't agree on anything that you're not comfortable with. Recently, I heard a contractor saying they stopped the contract. Said final arbitration is at ICC. I was thinking to myself, why did you agree to it? So you have to be very careful when you agree to dispute resolution clauses. Just now, other than that, there can be so many other clauses that you don't agree to. Then don't agree. I know sometimes the employers or the contractors might push you on. That's okay. It's never going to happen. You know, just get it done. They will say that. But you have to at one point set your foot down and say, well then, you know, I can't be a part to this. I am at least exempt myself from any type of liability when you get into trouble with this. So you have to make those decisions because as lawyers, we sometimes face that. We show them where it can go wrong and then they're like, and then it happens, they're like, oh, it happened. So don't agree to anything if they are upset. Always, so that's why if you're trained in negotiation or mediation, you will know the techniques to get people to avoid that. Because even on negotiating contract terms, we often go on the positions. I don't have enough time to explain this throughout, but if we take some examples, I could tell you how to avoid such terms and rephrase and get what is acceptable to both. So there are methods and techniques of doing those things. I hope it helped. 2 questions have come out. Okay, but shouldn't there be 3-way agreement with parties and mediator? A, specific basic mediation terms. B, mediator fees. So mediator fees you agree way before the mediation. Generally, mediators charge session fees. Very, very expensive senior mediators might charge hourly fees. Generally, it's from 9 to 6. They charge, a session is 9 to 6 for an entire day. That's how they block their days. It's not like arbitration that's half a day, 2-3 hour sessions. We keep our days for the entire day. And then we go. So you agree on fees, and fees is divided between parties. You don't have to sign anything with the mediator other than his commitment to mediate. Because if the mediator can't come and do the session the entire day, there's no point of getting him or her as a mediator. That's going to be another waste of time. But in terms of settlement terms, mediator is not going to do anything. He can't come and give evidence in court and say these people agree to do these things. Remember, it's without prejudice. It's only the 2 parties to give evidence and say, I agree to do this, I didn't do it. That's the only relationship. Because mediator didn't make decisions, you did. That's the difference. Joint venture company, main company closed with the court order. We have a project agreement with them. An arbitrator appointed by court. What is his duty? Decision made by him. Yes, it's arbitration. So if the court appoints an arbitrator, it means that you were not able to appoint an arbitrator by yourself. It's provided under the Act. Act says if the 2 parties are unable to appoint an arbitrator, then you can apply to the court and appoint an arbitrator. But it doesn't change the process. It's the arbitration process. So the arbitrator goes through the arbitration. Decision made by him. But since section 14 is there, you can ask him and get an opportunity to negotiate with the other party. You don't negotiate with the arbitrator. Negotiate with him, no. You negotiate with the other party. Act section 14 allows you to do that. With that, I'll end. Thank you so much. I hope there was something for you to take home and think about. Thank you so much.
Okay. So there was one feedback form. So with the QR, so I can move it. Yeah. Is it clear? So you can give your feedback from this lecture. So is it clear? Okay. Oh, if you have a soft copy. Okay, it can share. Okay, thank you, Sarani. So it's a wonderful evening and a full presentation. So I cordially invite our Civil Engineering Sectional Committee Chair, Madam Kamala Gunawardhanan, to give the token of appreciation. Madam Sarani, you also come to the audience. So the time was passed. So it was my privilege to deliver the vote of thanks on behalf of Civil Sectional Committee. Yes, Mrs. Sarani, you were delivered very truthful and time-bounded. The topic is the mediation. I think that due to crisis and a lot of situation, the construction industry faces a lot of dispute, and we are held up with those things. On this occasion, I wish to thank your boss, what you call your chief of party, Dr. INL Cruz, and also your colleague Apsara D. Silva, and she was given tremendous support, and also Melanie Andrea Pereira. And also, in this occasion, I wish to thank the people of America and the USA, those who have donate us and give the technical and valuable support for this country. And also, behind the scenes, we have a lot of encouragement and guidance given by our president, Engineer Dr. Kamal Laksiri. We wish to thank him, and also the president-elect, Professor Ranjit Disanayake, who was behind us and encouraged us. And also, not at last, our CEO, Engineer Neil Abhisekara, and also his team, especially Shamila, Chandana, and this, all the IT people, and also the people's from the IESL staff. And also, we know you are the strength for us, those who participate for this event. I hope you get some knowledge about the mediation and the importance of the mediation. So wish to have another session. We will invite you to have another workshop type in physical activity in future. We are planning to do it. And also small request, she will with a little bit of time, she will accept our invitation to come here. So I will thank all the audience and their valuable time with us. They are our strength. So I will stop from here, and I wish you have a nice weekend and happy Eve. Thanks.